No one lays down the law like Car and Key. This is the Law Report on SAFM.
And a very good evening to you from tonight's Law Report programme. Well, as you know, once a month here on the Law Report, we run a legal clinic trying to answer a range of questions on a number of different topics. And tonight it's again time to open the lines for you to ask that particular question that doesn't quite seem to fit into the other topics we discuss here on the Law Report. So I'm joined once again this evening by attorney Nicoline Skuman-Low. She's the director of Skuman Law Inc., attorneys, conveyancers and notaries, public practicing here in Cape Town. Nicoline, good evening. Welcome back to the show.
Hi, thank you for having me.
It's great to have you back. And if you have any questions, 0892 10 2010, 0892 10 2010, or SMS us on 40938. And just to let you know that hopefully this will be the last week that I will be bothering you. It is Wills Week this week, from today until Friday. And I know I've been going on and on about this for the last few months. And this is the last week I'm going to be bothering you until next year. But in the meantime, if you still haven't got yourself your basic will and you've just got a few days left, you might still be in time to get an appointment. Drop me a mail to law@safm.co.za. Tell me which town you live in, which province that is, and I will send you a list of participating attorneys in your area.
No one lays down the law like Car and Key. This is the Law Report on SAFM.
Right, it's our law clinic tonight. If you have any questions, 0892 10 2010, or SMS us on 40938. Before we get to these emails, Nicoline, you've got some interesting news for us for our next show when you're in. Something quite exciting.
Yes, actually, we're very excited to have taken the hands of the Western Cape Business Opportunities Forum, or WECBOF, and to be pushing a SME solution out into the market. More about that in more detail a bit later. But essentially, we believe that this would create more opportunities for SMEs, particularly in the Western Cape. That's where we'll start, and from there it will hopefully rapidly spread throughout the country. It will allow SMEs to have access to legal services at a competitive rate and instantaneously. So please keep a lookout for further developments.
So that we'll talk more about that next time when you're here.
Yes, I think let's save all the details for a bit later, but it's definitely something to look forward to, and it's something that I really believe is going to change things and will create more opportunities for the sector, so that they can shape and grow their business into to serious businesses that can be contenders on a larger scale.
Right, so let's get down to some of the emails before we start taking calls. And the first one says, I live in Cape Town and I need advice. My father told us he had a will. We had no concerns about it. He passed away last year in February. I am the eldest. My two younger siblings, both sisters, said they cannot find the will. What should we do to ensure that his estate or assets, if there are any, is settled, as we need to finalise the uncertainty?
Oh goodness, this is a very unfortunate situation, and unfortunately something I think from a practical perspective at the very least many people find themselves in. So obviously if you make a will, it's recommended that you put it in a safe place and you tell someone about it, particularly if you're storing it yourself, not with an institution or with your attorney and so on. So what often happens is, simply put, that the family can't find the will if there was one, or perhaps the family thought that there was a will and the deceased had changed their mind shortly before passing, so they had actually destroyed it or replaced it with another, and it's really a guessing game. So if no one can actually locate the will after taking some reasonable steps, then you need to assume that there was none. And if there was none, then the estate will devolve in terms of intestate succession, which usually benefit the surviving spouse and the children in a predetermined proportion. So it would seem that they'll probably get a little less than they possibly may have gotten if there was a will, or the assets will simply be divided equally as opposed to going to a specific individual.
So the first step now is what, to go to the master's office?
Well, the family, after someone passes, would have to actually look for the will, and if they haven't been able to locate it in order to send it to the master, then that's really where the problem lies. The master won't be able to have the will if the family hadn't retrieved and.
But I'm saying if they
submitted.
can't find it, then they have to assume it's an intestate.
Yes, and then they report it as such to the master.
To the master's office. Okay. But obviously look first. If you can't find anything, it's going to have to then be declared intestate.
Yes, I would just. The only recommendation I want to make is make sure that there is indeed no document. Make sure that you've looked everywhere, that if you knew who the attorney was, if there was a financial advisor or someone that would have taken part in the process of putting it together, make sure you contact them and make sure that there actually is none, or that if it existed, it was lost. But to get the certainty, or at least in some cases the courts have accepted a will where you proved that a certain copy was actually intended to be signed, or someone can bear witness to the fact that this was the will that we signed on this day. But of course it's never an easy situation. It's much easier to learn from this. But
try first, find out if possibly a financial advisor, possibly an attorney, ask around the family, maybe somebody else knows something, but do the best you can to try and locate that. There's been an SMS that says here, is it okay to laminate a legal document, or does it count as an alteration?
Well, it depends what type of legal document we're talking about. It wouldn't alter the fact per se, but remember, when you actually laminate a document, then you cannot really distinguish whether or not it's an original anymore. And that's perhaps where the alteration could come in. So in the context of a contract, then you'll have to explain why it was laminated, and that it, take the oath and say this is the original and I had it laminated to protect it, or whatsoever. If it's a will, on the other hand, then there's no way to really, well, I'm not a handwriting expert, but in my view, there's no real way to distinguish whether or not that was, in fact, in an original that you had laminated or not, which means that you'll have to bear witness to that and say, yes, I did see it, and, hopefully that doesn't render it invalid. So in the case of the will, it's a bit of a sensitive document, which I'd recommend you rather not.
Could I make a suggestion? What I do with all my documents I'd like to keep safe, I put them in a flip file, those plastic sleeves. It doesn't stick to anything, but it does keep it safe, and maybe do one of those. Get a flip file folder and put it in there. Yeah.
At the end of the day, I mean, I wouldn't know why you would
want to laminate it.
Yeah, but if you did, at the end of the day, it depends what we're talking about, and if it's a will, and you still have a chance to redo it. If you have laminated it, rather redo it. A will is a very sensitive document, unlike any other legal document.
Right, next email. I would like to know how much is the maximum interest rate that is legally permissible to charge my client when they borrow money. I really hate it when they call us loan sharks. I would also like to know if the law allows me to claim through the small claims court my money with interest from a client, even though I'm not a registered financial service provider in terms of the National Credit Act.
Okay, there are two sides to this. Firstly, the National Credit Act was amended a couple of months ago to the effect that anyone who extends credit, and there's a very broad definition of that, it's physically making loans, credit cards, store cards, right through to rendering a service or providing goods and delaying payment, or charging interest if payment is made late. So a credit agreement is a very broad topic in terms of the Act, and the Act was amended, as I said, a few months ago to make provision for no financial thresholds any longer, which means if you are extending credit, then you should be registered as a credit provider, particularly if you're doing it in as the course of your business. Which means if you are not registered as a credit provider, then there's always a chance, if you are trying to pursue a defaulting debtor, there's always a chance that you may, your credit agreement may be found to be unlawful, and the result being that you wouldn't have any legal recourse in terms of the breached contract. But you could still have recourse in terms of enrichment. So I'm giving that scenario to say it makes it very complicated if you are in the business of lending money or extending credit and you are not properly registered. So firstly, I would recommend that the listener gets themselves registered, first and foremost. Secondly, yes, you can claim the interest rate, or the interest which you can claim is one of two. If you're going to enforce your credit agreement, you can't claim more than a maximum of 27%. It's actually 26.48%, but, for ease of reference, just under 27. Or you can claim the legal interest rate, which means you're not enforcing a term of an agreement. You're saying you owe me money, you haven't paid, you're now in mora or in debt. And I claim the legal interest rate, which is currently 10.25%. So it's really a difficult situation. Small claims court, I'm not sure. Small claims court has a very low threshold. It's a little higher than it used to be now. But at the end of the day,
15,000 or something, isn't it now? Is it more than that?
18
Oh,
actually,
wow, okay.
If I'm not mistaken. So it's really important that they get themselves registered properly, because the registration with the National Credit Regulator allows you to do an assessment on the person you're lending the money to and to see if they can actually afford paying you back. From a business perspective, it makes no sense if you're in this business of lending money, if you're lending it to people that can't pay you. It's just a bad business model, if nothing else. So this really is not as onerous as people think. To have yourself properly registered and to have that certificate, it makes all your agreements legal. It gives you tools to ensure that you run your business responsibly and you actually make money. So I think that's the solution here.
Okay, we've got 2 more emails to go, but before we do that, Nicolene, the last time you joined us on the show, we had a call from somebody called Robin, who was having the most horrendous time with his car. Robin, you're back on the line. Hello, Robin? Robin?
Hi, can you hear me?
Yes, we can. Last time you spoke to us, just give us for those listeners who possibly missed you the last time, just very briefly, what happened?
Okay, so I initially had taken my vehicle in for an assessment. To cut a long story short, I had the company that I had spoken to confirmed that I would be able to get a free quote from them. After taking my vehicle through to them, they quoted me, I think it was 8,500 rand, which was under 9,000 rand. And I immediately voiced my dissatisfaction around what's the topic about the quote. Luckily, I know a little bit about the part that needed to be replaced, and told them that I can get the work done for almost half the price that they were able to do the work on. The guy initially had told me that they all of a sudden don't provide free quotes. They provide a free assessment. They use a different terminology. And at no point throughout the entire discussion had they mentioned that there would be any cost at all for the quote itself. And effectively, they wanted me to pay, initially it was 3,500 rand as a payment for them to do the quote itself. And after voicing dissatisfaction and having it escalated to a manager, to the owner of the branch, the guy told me to pay him 1,500 rand cash. And I think I mentioned to you guys, my concern was that he wanted the money in hard cash to keep it off the books.
And he wouldn't give your car back, if I remember rightly.
Correct. He wouldn't give the car back to me until I paid him the cash. I had called him to ask what your view is around the small claims court and all those things. And effectively what I had done was I contacted the RMI just to see if they can help me through the process. And I wanted to give you guys my opinion on what happened with the RMI. So the RMI had stalled for about a week and a bit. And I eventually got an email back just saying they preferred to go the mediation route. And my immediate response back to the RMI was, I'm not too sure if I agree with mediation, because that in my mind shows that they don't agree with where I'm coming from and my point. They've just sort of gone, they think I need to pay money, so there's a mediation process. I had spoken to a family member who was an attorney, who basically confirmed, similar to what you guys had mentioned, was small claims court may be a little bit of a lengthy process. They may damage your vehicle, so see what that mediation is about and then take it from there, because my thoughts were go through mediation, and if I had to pay and then claim it back or find some way to claim the money back. But effectively, the mediation wasn't the most client-friendly process. And I say this because the guy kept on mentioning to me, and this is the guy from RMI, he kept on mentioning why the motor industry is different to most other industries. So the motor industry being different to the investment in, also the finance industry or the retail industry, because I kept on making examples to him to tell him why I don't think I should be paying. So I gave him 2 examples, being if I had someone coming to do a quote in my blinds and I chose not to go with the person, and the person had told me he will provide a free quote, he can't all of a sudden choose me money for a consultation fee or money for pizza or whatever it was. And then the guy immediately mentioned, well, retail is different to the motor industry. And then I made an example on finance, being if I'm providing financial advice as an example, and I'm going to do a free consultation, and this person says, actually, your initial fees are too high, I can't all of a sudden say, actually, now you need to pay me a consultation fee. And again, he mentioned, well, the motor industry is different. And I kept on going back to this guy, pushing back, saying, how can you tell me the motor industry is different to every other industry that exists? And he said, well, you need to understand the industry. And I kept on asking him, so help me understand it. And he kept on pushing back. And it felt as though he wanted me to pay money. And I still, up until today, have a feeling that he's got a relationship with a provider that initially had given me the incorrect quote. And the reason I called him in is that it's so easy for the next person just to accept and say, actually, I'm gonna buckle. They're pushing too much pressure. I'm just gonna pay the money and write the money off. But I not kept on pushing back and pushing back and pushing back. Effectively, what they've done is my gearbox was out of my vehicle. They basically told me I can go and pick up the vehicle. They wouldn't even put the gearbox in the vehicle. So in my position, my car was actually in a much worse condition than what it was when I had taken the vehicle in.
Did they take the gearbox out, Robin?
They had, correct.
Well,
so
then
that is the issue. So they're saying that they had taken the gearbox out to do the quote. And my feedback to them was, had you told me up front that you're going to charge me to do it, I'm more than likely would not have used you guys. So what and I couldn't get back to them. This guy would not agree with me that he wouldn't even agree. And listen, when I say the guy, the RMI, he wouldn't even agree that I was correct. He kept on telling me this is why the motor industry is different. And he not once mentioned he agrees with me, and basically the other way around. At one point in the situation, he actually asked, can I please step out of the room so that he can have a private conversation with the owner that was there and the guy that had told me, had given me the incorrect information. And at that particular point I mentioned, I don't feel comfortable leaving because I don't know what's going to be discussed. And I asked him, will you discuss what you discussed with me? And he said no. And then I was like, I'm not too sure if I agree with that because that just felt wrong. And then he said, well, this is the way it works. And he said, he took the guy out and he went to chat to the guy in a different room. Up until today, I still don't know what they discussed, and the end result was them telling me they're going to put one screw in the gearbox to keep the gearbox in, but the car won't be able to drive at all. So I literally had to get a tow truck in, have the vehicle towed out, and then take it to a different provider that was able to do a much better job.
So you basically got the car back plus the gearbox. I'm saying plus because it was separate to the car at that point.
Correct.
And you haven't paid any money.
I haven't paid any money,
well,
but
good
only
for you.
Because of mediation.
Well, good for you, Robin.
The only issue was, had anybody not argued, had it been someone else, they would have filled it and just said, okay, I'll pay the 1,500 rand. Because it felt like a heavy bullied situation at that particular point.
Yeah, I mean, I think it's ridiculous. Nicolene?
Yeah, this is really quite disappointing actually to hear. These ombud structures are there to be the mediators between the public and the provider. And they need to explain the mediation process to both sides adequately. I'm a mediator myself, so I'll tell you that one of the first things that I do in the mediation is to explain to the parties how the process works and to say we are going to go through the process where you can say what your side of it is, and we do it transparently and openly, and after that we break away into separate sessions, and the purpose of the separate session is to gauge whether there are any points on which either of the parties or both of them would be willing to compromise on, so that you can meet each other halfway and you can move forward. So perhaps it wasn't articulated well enough, but a separate meeting isn't necessarily something to frown on. It's I suppose it depends how it's applied, but the mediator should be impartial and should aim to look for points of points that are agreed, and to see that where those that are not agreed on, how we could find a way to compromise in that space, and if it's possible at all. So maybe not very well communicated, but it is an effective tool. We call it caucusing. So it's an effective tool if you really want to get to the bottom of what either party's real grievances are.
It didn't seem to work terribly well in Robin's case. But Robin, we've got to move on now. But thank you very much for filling us in on the rest of that story. And I think it's a good lesson for others out there, as you say, not to be bullied into something when you're not happy about it. So thank you so much for giving us the follow-up to that story. Thank you. And good luck with the car now, Robin.
Thank you so much.
Thanks so much. Bye-bye now. Right, we've actually got some more calls lined up. We've got some SMSs holding on. We're going to try and get through some of these quite quickly. The next email says, I live in the Eastern Free State in a rural place called Kwakwa. I have a problem with maintenance. I'm a security official. I'm maintaining my 2 children, but their mother denies me the opportunity to see my children. Can you please assist me by giving me the contacts where I can get assistance from? Because I feel that the court is unfair to me because I pay maintenance, but I can't see the children. The worst part is the court ordered my employer to take the money from my salary direct to the lady's account, and they take a lot of money, and it's really stressing me.
Well, first things first, I think the issue of access and the issue of maintenance are 2 distinctly separate issues. They're often dealt with in the same proceedings, usually in divorce proceedings, whereby it's agreed how access is going to work and visitation will work, and then, of course, how the maintenance aspects will work, who gets the money, or will the provider be paid directly, etc., etc. So often, because they tend to be agreed in the same forum or in the same document, people often think that they are in the same, or they are linked to one another. That if you pay your maintenance, then you have access to your children or visitation rights, or if you don't pay, then you don't have access. And I actually want to make it very clear that they are 2 very distinct, 2 very distinctly separate issues as such. So, if there's an issue with visitation, it's something that it's not directly related to whether or not maintenance is being paid. And I'm not suggesting that you stop paying your maintenance at all.
Because I congratulate him on being one of those fathers who is stepping up to the plate, because there's way too many of them that don't.
Exactly. So, and if you feel that it's too much and you have reasons and you can prove affordability or questions regarding that, then you're always free to approach court and to ask for a variation in the
maintenance
amount.
Court.
The maintenance court. If the issue is visitation, then family court would be the place to go, and then to have the visitation agreement. It's usually a visitation agreement that is put together with the help of the family advocate, that can be revised, or if there is none in place, which I'd find odd, but if there is none in place, it has happened on occasion, then one can put that in place and say, I want every other weekend, these are the arrangements, these are the times, this is how it's going to work practically. So I would say if money is of concern, perhaps approach legal aid, get someone to help you uplift the file, look at what is in there, what has been done, what hasn't been done, what needs to be done to achieve the end, and take it forward from there.
Okay, I do have this listener's email address, so what I will do possibly is try and find a legal aid office close to where he is in Kwakwa and send him some contacts, and then maybe he can start there, and that will possibly be the first port of call.
Yes.
Okay, great. Before we note the next email, we'll just take one of the SMSs. My son is the only beneficiary in my will. Can I elect him as the executor as well?
Of course.
You can.
No problem with that.
So that's quite...
He just shouldn't sign as a witness to your will, please.
But he can benefit,
yes,
and he can be the executor.
Yes,
just cannot be a witness.
It's actually a good thing to be both the beneficiary and the executor, because then it's in your best interests also to ensure that the administration gets done swiftly, and if any fee arrangements need to be made with an attorney or someone helping you with the administration, you're in a better position to bargain.
Right, so that's the good thing. Next one, I have assisted a friend and took a loan to help him financially, yet we did not have a written agreement. He's been giving me hiccups with monthly payment, monthly installments, yet I would like to go to the law go the law route to pin him or have the money deducted from his salary? How can I go the law route yet avoid making him a commitment of paying less than the monthly installment? So, other words, length, but there's no agreement, so that you can't. Can you enforce that then?
You can allege a verbal agreement, but of course, then you'll have to prove your case in court, and that's going to take quite a long time, and often costs more money than the amount involved. If the person's paying, I would suggest that you don't.
It looks like they haven't been paying now, so that's the
so
problem.
they paid and then they stopped.
Yeah.
Obviously, it's if they've paid and then they've stopped, it's maybe a better route to consider an acknowledgement of debt, just to formalise the payment arrangement. If that fails, and you've had the document signed, at least you've got some written document, so you can get to an attorney to assist you with that. Or you can go the route of going to court, but know that it's going to take a long time. It will probably cost you more than the loan amount. And there's always a risk that the court is going to award a lower amount than what the person used to pay. Because maybe, don't know what their personal situation is. Maybe they are unemployed now, or they've got a lot of commitments, or even perhaps they are overcommitted. And they've you're just one of many creditors standing in line to get your piece of the pie.
Right, another SMS, and I'll just try and shorten this a little bit. Basically, there was a son, he was 28, he married a woman, they eloped, the marriage was registered, and the father doesn't seem to approve of the new wife. And he's quite concerned because he says the son has breached his trust because the father didn't approve of the now wife. The father also says, I fear for my life, as the son could poison him in order to get the inheritance. And he says that being my biological child and his offspring, the biological grandchildren, one day will be able to inherit the estate. The son apparently also has access to an online connection to shares he has on the stock exchange. He says poisoning has happened in my family before, so this aspect is not far-fetched in my case. How can I cut him out of my will to give him no motivation to poison me? It basically just don't put him in the will.
Yeah, basically don't put him in the will. And if there is maybe a grandchild that is minor or is on the way, then you can always create a trust and bequeath all your worldly possessions to the trust, and the trust can then deal with
and the son would have no access to that.
So yes, you skip the son essentially. So you don't make him a trustee, you don't make him an executor of your will.
Or a beneficiary.
And all the benefits go to the trust, and it's for the benefit of any grandchildren.
So there's just nothing more to the fact that just don't include him.
Yes.
Just don't put him in there.
Either you don't include him at all, or you include someone else and skip a generation.
Right, last email says from Nina. She says they paid in February in 2015. They paid a particular company in Pretoria 45,500 rand. They ordered several structures to be erected, and they were apparently, by the sounds of it, away. They were overseas. The problem now is nothing's happened in the time, basically 92 years later. The problem now is this woman still trades and has just posted new photos on Facebook. Myself and my family have tried to contact her repeatedly, but she blocked all our numbers and WhatsApp and Facebook. I handed her case over to a lawyer in Dar, and they've been unable to contact her. Then she gives all the contact details, which I'm not going to tell you now. And then she says, I believe she's just moved premises to somewhere else in Pretoria. All I want is either my money back or the structure to be built. What to do?
It's really unfortunate. We see so many variations of this type of thing happening. I think lesson number one is don't prepay for things, particularly if you're not around when the delivery needs to happen, when you're overseas or traveling or so on. And unfortunately, particularly in the construction industry, we see this type of thing happening where it's a large sum is prepaid and then the delivery is never made or the job is never completed. But it's not confined to that industry, of course. So first things first, it's happened now. You've got 2 years already into it. I would suggest sooner rather than later you hand it to another attorney if you're unhappy with the one you have briefed. And they need to appoint what we call a tracing agent or a private investigator to get a good address where you can send a summons to. It's a fairly low amount of money in terms of if you have to fight this thing in court and trace them and pay investigators and so on to get these people, then you are going to pay at least that amount in legal costs to drive this case. That's the unfortunate.
Yeah, so it's not really fair, you know.
No, it's definitely not fair. You could, of course, report this, but, you know, our police service are inundated with all sorts of cases on any given day, including their commercial crimes unit, which means that and then, of course, you'll have to prove fraud and that this was a scam. So, you know, if you know of other people that have had a similar experience, then it's something you could look into. But at the end of the day, unfortunately,
there was a case here in Cape Town a couple of years ago, a similar kind of situation, and the last person that had got scammed was like, that was it. And so he put a piece in the local newspaper, and the response was ridiculous. And they then almost like this class action, if you like, in inverted commas, of people, and somehow they actually found the person, but there was enough of them. Because maybe what Nina should do is maybe put it in their local newspaper, and just say, look, has anyone else had the same issue with these people?
Or on social media and ask the question. I mean, don't slander them.
No, just ask.
But ask and say, this happened to me. Perhaps don't name as many names and
no, don't give all those contact details and things. No,
because that breaches a whole different topic
Privacy
of privacy
stuff,
issues. So maybe just outline your experience and who you dealt with in terms of the business name, and ask if someone else has had a similar experience and see where it goes. Maybe you get responses and one can then bring a class action of sorts, or at least you know if it's a fraud, a scam.
Right, well, we'll be back with you shortly with some more of your phone calls and questions on our monthly law clinic.
No one lays down the law like Car and Key. This is the Law Report on SAFM.
Right, off to Secunda. Gregory, good evening.
Very good evening to you, Carl, and good evening to your guest.
How can we help, Gregory?
Carl, about a year ago, I did a these short course colleges, very recognized short course colleges. I did a short course, and there were 3 subjects, and I failed the one, so I had to pay again to write the subject that I failed. And I got almost the exact same marks, just with like an extra %, which I failed again. And the thing is, Corin, I worked very hard to pass this exam. I did my utmost best, and I don't believe that I failed. I probably got about 95%, let alone fail. And I'm I'm a learned person. I'm an intellectual, so I don't believe that I failed. But I'd like to take the college to court for them to release the answer sheets and to get some closure on this matter. And I'd also like to know what are the statutes of limitations with this matter.
Have you, just before Nicolene answers your question, Gregory, just a question from me. Do you know anyone else who's had a similar problem at this college?
No, absolutely not. But there's always a first.
No, I was just wondering whether maybe there wasn't possibly some way of them wanting you to rewrite to get the extra fee. You know, every time you rewrite, you've got to pay again. So I thought maybe
it will be the third time, and I don't think there's anything that I would change if I had to rewrite it again, because I'll probably put the exact same answers, and which I know those answers were correct.
Okay, Nicolene?
Have you opted for a remark as yet?
Everything is just money. And,
no, but I think you'll need to exhaust all internal remedies before you stand any chance of taking this to court. So you need to have it remarked, and if the same result is forthcoming, then your next step would be to ask for the memos and the answer sheets and all those things, and if they refuse, then you can bring a High Court application, which is going to cost you, I would say, depending on which advocates and things you use, anything between 40 and 100,000 rand if you're lucky, maybe a little more. But then at least you can force them to give you reasons and give you a proper synopsis of where you went wrong and if you were wrong or if they were wrong.
So basically, but what the next step is to ask for do a rewrite, then you can actually ask them for those.
A remark,
sorry. The remark, and then if you still don't get the answers, you can actually ask them for those the papers yourself.
There should be an appeals process
At the college.
At the college after the remark has happened, which tells you if you're still dissatisfied with your marks, which process you need to follow, who you need to contact, which forms you need to fill in, and so on.
When
But
did you
need to do these? If you don't take these steps, no court will entertain such an application because it will refer you back to go and exhaust the internal remedies.
And the thing is, if you do
first.
that, it could cost you nothing to do that.
Exactly. Well, almost nothing in
Other
comparison
than
to a High Court application.
And Gregory, when did you actually do the rewrite? Because you asked about statute of limitations.
I did the first one in 2016, the second one this year. Okay, for example, if I do follow the procedures that you'll follow, and I'm unhappy with that, if to take this to court, would it be in the major centres, because they do have the colleges in the major centres? Will it take place in one of the major centres where the court case will take place?
You need to remember that although these colleges may have different campuses, they are usually, and I don't want us to say who you're talking about on air, but usually these are franchise structures, which means each college is individually owned, and they only share branding with a centralized body. So you will have to go to the specific college where you've had this experience and where they are situated. So, for example, if they are situated in Cape Town, then you'll go to the Cape Town High Court.
But your best
Okay,
bet...
and the statute of limitations, ma'am?
Yes.
Is there one?
Well, if you want to claim your money back, then the 3-year period, all claims expire or prescribe within 3 years. But you are looking at clarification on an administrative process followed, which means, yes, there's a much shorter one. There's a 6-month period in terms of the Promotion of Access to Administrative Justice Act, within which you need to exhaust your internal remedies and ask them for their reasons. And if they fail to respond only after the 6-month period has lapsed, can you move forward. So time is of the essence. And if the time has already lapsed, then you'll have to show good cause why you waited so long.
Okay, Gregory.
And if they take their time in giving me my answers on anything, questions that I need?
Well, it depends what the response is. So if they give you a remark and you're unhappy with the remark, then you can ask for the reasons. And if they take too long a time, then there are other mechanisms in the legislation that one can use and in order to escalate it. But at the end of the day, it's more about you approaching them within 6 months than it is for them to respond. And obviously, if they take unreasonably long, then you're back at going to court and forcing them to respond timeously.
Okay, Gregory, good luck with that. Thanks for getting through this evening.
Thank you very much.
Thanks a lot. Okay, good night to you. Right, off to Middelburg. Eric, good evening. Eric?
Good evening.
Hi. How can we help you, Eric?
Corinne, I have got a case. In 1992, my parents, that's my mother and my sisters and my brother, they gave me the right to build on my elder brother's property who was mentally ill. Then I built a house there, and this guy, my brother, then went home and built his house at our family property. So I moved out and went and built at his stand, which is in his name, and the title deed is on his name. Now he has passed on, and all my parents, my brother, my sister, and my mother, they've all passed on. And now I'm faced with a situation where his children are rightfully claiming the property on which I have built the house. Now, the dilemma that I have is that what recourse do I have in order to claim the right of ownership? Because the biggest issue here is that had I known, I would have dealt with the issue of transfer as soon as possible, but I didn't do that. So I would like to seek your advice, Karin.
Okay, Nicolene?
Now this is always a sticky situation, especially if there's no written agreement in terms of what was agreed all those years back. And it is a long time ago, so people may have different versions.
But just before you carry on, Eric, I read something here on the screen that your mother left the property to you, but it was in your brother's name.
Yes, actually my mother is the one who said I can go and build at this property.
Now, was it in writing at all, Eric, or did it just tell you that?
No, it wasn't in writing.
Okay.
It was just a verbal issue.
Okay, now I just wanted to check that.
But worried that the guy is mentally ill, he will not be able to build, and there was a greater chance that the property might be taken by,
Okay.
by other people.
Yeah.
Now, of course, there are valid reasons, so I think it would have been better if it was in writing, but it wasn't. I assume your mother left a will, and it was in that will that she left the property to you, even though it was registered in your brother's name.
Did that happen?
No. There was
nothing.
No will at all.
See, the best case you have, there is a provision in the Deeds Registries Act, the legislation that deals with property transfers. There is a regulation that you can use to bring a court application to ask the Registrar of Deeds to transfer this property now, so many years later. And what you'll have to do is you'll have to bring witnesses to collaborate or rather corroborate your story in terms of what transpired all the way back in those days when all these discussions happened and all of that. So you'll need to bring witnesses. A lot of time has passed, but hopefully some of the other family members would recall this, and you could actually bring them together and you can launch this application. That's the best chance you have of rectifying this.
So you have to get yourself a property lawyer to go with you. Property
lawyer, legal aid you can try, but you'll need someone that knows their way around this. You'll need a combination of conveyancer and litigator.
Okay.
Okay.
When my brother passed on, I was appointed as the executor. There is that letter of authority to administer the estate. But later on, his children came up, and they went to the I think it's the Supreme Court or one of the courts at higher level, and the letter of authority was overturned, and I was taken out, and they then through that claimed the property, and they are now residing in the in the property.
So you've got a problem there, Eric. Yeah.
Sorry?
You've got a bit of a problem, it sounds like.
You'll need a specialist to help you with this. I would recommend that you contact your local law society and get a few names of specialist property lawyers that are also good at court work, and even they may even have to seek the advice of an advocate. I'm sorry to say, from what I'm hearing, the more this thing is rolling out and developing, the more my inclination is that get the advice, but prepare yourself possibly for some bad news. I'm sorry.
You need to get legal advice. We can't actually help you on the show. It's just too complicated, Eric. So I think let's go to legal aid or to the local law society, and hopefully they'll be able to put you in touch with an attorney that can help you. Good luck with that, Eric. I'm so sorry to hear the story, but good luck with that. Thanks for getting through. Good night to you. We'll be right back with you with some more Law Clinic now.
No one lays down the law like Car and Key. This is the Law Report on SAFM.
Right, we've just got a few minutes left. We're going to try and squeeze in as many as we can. Bonga Nkosi in Standerton, good evening.
Good evening, how are you?
I'm very well, and you? How can we help you, Bonga Nkosi? You want something about buying a car?
Yes, I just want to find out what are the legal route if I were to buy a car that was bought by person B from person A. Say person B did not have the ownership of the car from person A, and the person B, they have lost contact with person A, and now person B want to sell the car, and the car does not have the ownership.
Okay. Nicolene, it's basically don't buy the car from them.
Yeah, I was looking for a diplomatic way of saying that. But unfortunately, we can't recommend that you proceed with the transaction. At the end of the day, if there's no registration papers proving ownership, then, and it may be a story, you need to consider that. I know we sound very pessimistic when we say that, but it may not be a case of losing touch with person A. It may actually be that person A doesn't know that person B has their car. So it may actually be a stolen vehicle.
There have been cases where people have bought cars from person B, for example.
Yes.
And the next minute, you've paid person B all the money for the car, and the next minute, the police arrive and confiscate the car because it turns out to be stolen, and you don't get your money back. And that has happened a lot.
It does happen a lot, and it's actually one of the things we recommend. If you are looking at buying a car, particularly, well, I think in all cases, but particularly if you're buying it from an individual, you need to take it for a roadworthiness test, and you need to take it to a testing station that can give you a police report, so that you can ensure that the person you're dealing with is the actual owner of the car.
You take it for police clearance. They have traffic department has special places where you go to get police clearance on a car. And then you can make sure the car isn't stolen or there's something wrong somehow that person B ended up with the car. Bonga Nkosi, if you're the person looking to buy the car from person B, I would recommend, and so would Nicolene, don't do it.
Don't do it.
Yes, because what I have done, and I did take the registration number for the car to the police station, and then from the police station and from the traffic department, the car is not stolen, and the person stopped to pay for the license on 2015.
Yeah, but also the
only problem is that how am I going to take the ownership of the car?
You can't.
Person A is nowhere to be found.
You can't. And the other thing, though, Bonga Nkosi, just one other thing of advice: taking the registration number is possibly not going to be the best way to check that the car is not stolen. There's something called a VIN number that actually is printed on. It's sort of like engraved into the engine of the car. That is what defines the car.
I have all those papers.
No, but not the papers. They need to take the car so they can see the VIN number on the car. Written on a piece of paper isn't helping you.
Oh, okay.
You need to have the actual physical car at the police clearance place, because they need to check that VIN number is in all the right places. It's in more than one place on the car. And they need to check that it's all the right parts, it's all in the right place. And, it's also the engine number, the chassis number, all those things have to be on the car.
Different numbers.
You need to go and take the actual car. Taking the registration number isn't really going to help you. But if I was you, I would steer clear of this car, because you'll never be able to take ownership of it.
No, it's an impossible task.
Save yourself a lot of trouble.
No, then.
Thanks, Bonga Nkosi. Good luck with that.
Sure.
Thanks. Okay, bye-bye. Oh, I get quite because I know people. I've read stories of people who've lost all their money when they bought cars from person B.
Well, we've personally encountered it also.
Really?
Where clients have actually. They get all the papers, but the papers are actually unauthentic.
Yeah.
So by the time they are happily on their way, they get stopped at a routine roadblock, then you find out you're in possession of a stolen car, and as you say, then person B has disappeared into thin air and you can't get your money back.
Yeah. Right, we're going to try and squeeze it. We've got about 2.5 minutes. Joseph in Gauteng, good evening. Can you ask a question very quickly?
Okay, good evening, Karen.
Good evening.
Yes, it's straight to the point. Okay.
Yes.
Is it possible to a judgment to be taken against you after you paid a month's claim on a summons?
Technically, it shouldn't happen, but it is possible. It's possible because of an administrative oversight that may occur. So you get the summons, you pay, let's say you pay the attorney, and the attorney, for whatever reason, allocates it wrong, or you pay your creditor directly and they never tell their attorney, and the attorney just goes ahead and takes the judgment.
Okay, it's fine. I can see the time. Okay, it's not, doesn't fall under Credit Act. It's consulted with a law firm, and then from there on, they issue someone. The amount was 1,000 rand. So then they issue someone that paid them. So we went to court. They took me to court as a defendant and everything from there. But one thing I've discovered, this thing happened in 2015. I don't have a proof that I've paid amount. I even went to such an extreme that to go to the bank to request that I've made a deposit. And it turns out that in court, they're not disclosing the proper date they received the payment. They're disclosing the wrong date. And they're saying that I've paid after the judgment was taken against me.
Oh, gosh, Joseph. Well, the only thing you can do is try and get that thing from your bank to prove the fact that you made the deposit and then prove them wrong.
Yes, the charge now I'm faced with, it was 400 rand amount that there's, okay, it was 1,000 on a summons. So now we're sitting at 5,000 rand as the balances of payment. And to get a lawyer, it's going to cost
you a lot more.
The same amount of money. And to acknowledge that as a judgment, it's just a bit of a situation where the court, mentioned that, you know what?
Joseph, I'm going to have to say, I'm so sorry, but we literally got 45 seconds left. We're going to have to go. But thank you so much for getting, and good luck with that.
Okay, thanks, bye.
Thanks, Joseph. Bye-bye now.
Bye.
Well, my thanks once again this evening to Nicoline Skumanlo. She's a director of Skuman Law Inc., attorneys, conveyancers and notaries, public practicing here in Cape Town, and she's been my guest on tonight's edition of the Law Report program. And we'll be doing another law clinic on Monday, the 9th of October. Nicoline, thank you so much for joining me again.
Thank you for having me.